Hi friends, welcome to our channel. Today we are diving into a powerful tool that can make a huge difference in how Industrial Disputes Act 1947. Today I will explain in this video about the Industrial Disputes Act 1947 along with Industrial Disputes Central Rules 1957, Industrial Disputes Karnataka Rules 1957, Industrial Tribunal Central Procedures Rules 1954, Industrial Disputes Banking and Insurance Companies Act 1949, Industrial Disputes Banking Companies Decision Act 1955, Industrial Tribunal Procedure Rules 1949. And now we can go to the content of the Industrial Disputes Act 1949. The guidelines to Industrial Disputes Act 1947 I will explain. The Industrial Disputes Act 1947 Act as it stands today is the result of a series of ameliorative legislations commencing from Bengal Regulation 8 of 1819 to the last amendment to the present Act in 1984. The objective of the Act is to protect employees from exploitation or whimsical directives of the employer. Extensive in its operation, it shows an overwhelming bias towards the workman and bears heavily on the employer. The Act is a beginning measures which seeks to preempt industrial tensions, provide mechanics for dispute resolutions and set up infrastructure so that the energies of partners in production may not be dissipated in unproductive battles. The Act was passed to provide machinery and forum for investigation of industrial disputes and for their settlements. The Act enables the state to bring about a comprehensive obligation on the employers and the workmen alike to seek resolution of their disputes through arbitration. The personality of the whole statute has a welfare basis, being a beneficial legislation designed to protect the interest and welfare of workmen. The Act regulates situations of crisis or tension where production may be jeopardized by unlawful strikes, blackmail or lockouts. The rule of this law is sympathetic and regulates benefits to workmen in a situation of conflict between them and the management. The principal objectives of the Act have been precisely stated by the Supreme Court in Workmen of Dhimakuchi Tea Estate, Assam Raja Karamchari Sangha. Dhimakuchi Tea Estate to be promotion of measures for securing and preserving amity and good relations between the employer and workman. Investigation and settlement of industrial disputes between employers and employers, employers and workmen, or workmen and workmen with the right of representation by registered trade union or a federation of trade unions or an association of employers or a federation of associations of employers. Prevention of illegal strikes and lockouts. Relief to workmen in the matter of layoff and detachment and collective bargaining. The fact that the Act has so far been amended as many as 31 times by Parliament is a pointer to its continuing concern to remain contemporary with the emerging awareness of the workmen of their rights, both actual and potential. Scope and applicability. The distinctive feature of this Act is that all factories and establishments, irrespective of being registered, are not under any other Act, and regardless of the number of employees on the roll will come under its purview. The Act applies to every business trade, undertaking service, avocation, etc., which is considered as an industry under this Act. Definitions of terms. What is an average pay? Average pay means average pay of 3 calendar months in the case of workman paid monthly. Average pay of 4 weeks in the case of workman paid weekly. Average pay of 12 working days in the case of workman paid daily. The periods of the 3 completed calendar months, the 4 completed weeks, and the 12 full working days, as the case may be, will relate to the period preceding the date on which the average becomes payable to the workman. Where such calculations cannot be made, the average pay shall be calculated as the average of the wages payable to a workman during the period when he actually worked. What is an industry? Industry means any synthetic or systematic activity carried on by the cooperation between an employer and his workmen, regardless whether they are employed directly or through a contractor for production and supply of goods or services. It is immaterial whether or not any capital has been invested by the venture. The true test is whether an activity is functional and whether there exists in it an employer to employee relationship. It does not cease to be an industry only because of any philanthropy animating its objectives or because the workers, besides receiving wages, share the passion for the cause. The amendment of 1982 has excluded from the scope of the term industry institutions like hospitals, scientific, educational, or research institutes. The scope of the term workman has also been enlarged to cover the supervisor staff whose wages do not exceed 1,600 per month. For an establishment to be called an industry under this Act, absence of profit motive is irrelevant. The focus of definition will be on the finality of the establishment. The decisive test will be the nature of activity and would lay specific emphasis on the status of employer-to-employee relations. The establishment does not cease to be an industry only because of any philanthropic objective animating it. Bangalore Water Supply and CVH Board, Rajappa and others, V&E. The Act does not therefore strictly define industry but only seeks to describe it. An easy test to determine the state of an undertaking is, of course, what the Act itself lays down, namely whether in an undertaking there exists systematic activity. To a cooperation between an employer and employee, the direct and substantial element being chemical and through production or distribution of goods and services, calculated to satisfy human wants, such wants and wishes being material things and not superficial or religious. This test would consequently exclude from the definition of industry, for the purpose of this Act, undertakings and establishments which render services which are purely for fulfillment of spiritual or physiological needs of persons rendering those services. An alternative test would be to investigate whether a dispute arising between the employer and the workman or between workman and workman would fall within the sphere of disputes arising in the course of an industrial activity. Both the alternative tests are admittedly unspecific. The Supreme Court has warned itself not to fall into the trap of definitional expansionism or nor to truncate the obvious amplitude of the definition of industry to fit into its own mental would-be mold of place and prejudices. Supra. The definition is limited to those activities systematically or happily undertaken and on commercial lines with the cooperation of employees for the production or distribution of goods or for rendering material services. In the case of liberal propositions, the contribution of the usual type of employees to the value of the net product is so manageable that the net product cannot be regarded as a fruit of cooperation between the provisional entrepreneur and his employees. Is agriculture an industry? Is agriculture an industry? Going by the non-technical and ordinary meaning of the word industry, the undertaking where capital and labor cooperate with each other for the purpose of producing wealth will be brought within the pale of an industry. In this sense, the question whether agriculture, horticulture, pisciculture, etc., where industries, whether agriculture, horticulture, pisciculture, etc., were industries, came sharply for consideration. The answer was not available, came sharply for consideration, either in the Act or in the pronouncements of various high courts until 1978, when the Supreme Court enunciated that any activity connected with agriculture or agricultural operations affect industrial or labor disputes or welfare of laborers might fall within the ambit of the word industry. If such activity specifies the triple test laid down in the definition provided by the Act, certain typical activities. Educational institution. In the case of a university or an educational institution, the nature of activity is ex hypothesis education. This being a service to the community, university or an educational institution is an industry. But in the case, the question before the Supreme Court was not whether an educational institution was an industry. Court was not whether an industrial institution was an industry. The court interference on this point was therefore in the nature of an arbiter. Even so, the court did not specifically test the question whether the activity of teaching would fall within the definition of industry, and therefore whether a teacher would be a workman. This question is therefore still open. A subsequent decision of the division bench of the Bombay High Court was that the nature of the work of teachers teaching in educational institutions will not fall within any of the categories of work enumerated in the Act. The court held that on an appreciation of the nature of the work done by a teacher and analyzing the definition of the term industry, the teacher is not a workman. Miss A. Sundramambal, Government of Goa, Daman and Diu, and others. Cooperative societies and credit unions. Even where cooperative societies are certified by members only, the entity is industry, for the reason that the member workers are paid wages and that there can be disputes of industrial nature, such as disputes about rates and scale of wages. Such disputes may be between management and workers, or between workers and workers. For similar reasons, credit unions would also qualify for the definition of industry. Bangalore Water Supply and Sewage Board, a Rajappa and others. And clubs, the Supreme Court in Bangalore Water Supply and Sewage Board case stated that if a club or other like collectivity has a basic and dominant self-service mechanism, a modicum of employees at the periphery will metamorphose into a employees at the conventional club whose words and virtue are looked after by the paid staff, while the role of the members is only to enjoy themselves. The same court in Madras Gymkhana Club employees. Union Gymkhana Club observed that the club in question was not an industry because it was a self-serving institution, that the services were to the members themselves for their own pleasure and amusement and the material goods for their own consumption. On the same principle, the activities of the Cricket Club of India were also seen as to fall outside the definition of industry. Cricket Club of India Limited, Bombay Labour Union and others. The Supreme Court has not accepted this reception in Bangalore Water Supply and Sewage Board's case. The active clubs, the Supreme Court said, would fall within the definition of industry because they respond to the triple test laid down by it. Never themselves, the Supreme Court appointed out that by this token and logic. If a club or like collectivity has a basic and dominant self-service mechanism, a modicum of employees at the periphery will metamorphose it into a conventional club whose verve and virtue are taken care by the paid staff, and the role of the members is only to enjoy themselves. The smaller clubs manned by members themselves might not fall within the definition of industry, whereas clubs in upper brackets such as Gymkhana Club, Cosmopolitan Club, Cricket Club of India or National Sports Club of India, where pleasure of members is paid for and provided by skilled or semi-skilled workmen, would fall within the definition. Provisions. The Act does not eradicate the word professional, but leaves the word to be best understood contextually. A profession is a calling involving individual activity characterized by personal skill, knowledge, and intelligence. A single lawyer, a rural medical practitioner, or an urban doctor with a little assistance may play a profession but may not therefore be said to run an industry. The very concept of the liberty professions has its own special and distinctive features which do not permit inclusion of professions within the concerns of industrial law. A person carrying on a liberty profession does not do so with the active cooperation of his employees or his principal. A further reason for the exclusion of the liberty professions from the preview of the industry could be that the contribution of the employees would have no direct bearing on the final product, namely advice or service of the professional person. Among the more familiar liberty professions are the following. A. Legal. A firm of solicitor has been held to be not an industry. That means National Union of Commercial Employees and another Industrial Tribunal Bombay and others. Subsequently, however, the same court overruled this decision in Bangalore Water Supply and Sewage Board case, Supra, where it held in observed that the offices of the practitioners of the legal profession would fall within the definition of industry if they fulfill the triple test, namely, first one is systematic activity, and the second one is organized by cooperation between the employers and the employees, and the third one is the production and distribution of goods and service calculated to satisfy the human wants and wishes. The every concept of the liberty professions has its own special and distinctive features which do not permit inclusion of professions within the concerns of industrial law. A person carrying on a liberty profession does not do so with the active cooperation of his employees or his principal. A further reason for the exclusion of the liberty professions from the preview of the industry could be that the contribution of the employees would have no direct bearing on the final product, namely advice or service of the professional person. Among the more familiar liberty professions are the following. A. Legal. A firm of solicitor has been held to be not an industry. That means National Union of Commercial Employees and another Industrial Tribunal Bombay and others. Subsequently, however, the same court overruled this decision in Bangalore Water Supply and Sewerage Board case, Supra, where it held in observed that the offices of the practitioners of the legal profession would fall within the definition of industry if they fulfill the triple test, namely, first one is systematic activity, and the second one is organized by cooperation between the employers and the employees, and the third one is the production and distribution of goods and service calculated to satisfy the human wants and wishes. Medical, there does not appear to be so far a case coming for specific consideration of the question whether the activity of carrying on a medical profession is an industry. The Supreme Court observed once again in arbitration that if a hospital or nursing home or dispensary is run as a business in a commercial manner, there may exist the elements of industry. Such an institution will then be more than a place where persons can get treated for their ailment. The activity will then become a business and therefore an industry. Management of Subterranean Hospital, Kuldeep Singh Sethi. The decision is Bangalore Water Supply and Sewerage Board case stands as at present as the authority to repel any attempt to excel the liberty provisions, including medical provisions, from the preview of industry. There have been conflicting judgments of different high courts, some holding that a firm of chartered accounts is equivalent to an industry and other accepting it from the word industry. The differing viewpoints have been warning to the equation presented by the test of organized cooperation between the employer and the employees. The only capital of the chartered accounts being his professional qualifications, skill, training, reputation, one does not see the existence of a cooperation between capital and labor. The courts have seen that the aid which a chartered accounts might obtain from The courts have seen that the aid which a chartered accounts might obtain from a clerk was by no means essential or indispensable to the practice of his profession. At the same time, the test of cooperation might have to be answered in the affirmative in case of large firms of chartered accounts where labor is both numerous and systematized. Upon the pronouncement of judgment of Supreme Court on the Bangalore Water Supply and Sewerage Board case, some of the officers and activities of the chartered accounts would qualify for inclusion in the ambit of industry. Architects, the decision of the Supreme Court in the Bangalore Water Supply and Sewerage Board Supra has unequivocally laid down that the offices and activities of architects would fall within the preview of industry if they answer the triple test laid down by the court in the same judgment. What is an industrial dispute? An industrial dispute means a dispute or difference arising or occurring between employers and employers, or employers and workmen, or workman and workman, and which is connected with the employment or non-employment, or the terms of employment, or with the conditions of the labor. The expression industrial dispute has been so widely defined as not to leave out of its comprehension any area of conflict that may develop between the employer and the workman, and in respect of which conflict a compulsory adjudication may not be available. Krishna Ram Union of India and others, the definition of industrial dispute contained in the Act unambiguously declares that the Act does not contemplate a dispute or a difference of any sort, but that it contemplates only such disputes or differences that bear upon the relationships of employers and workmen. The term of employment and conditions of labor, the adjective industrial used in the phrase ipso facto means a dispute or a difference arising or occurring in an industry. It therefore follows that the Act does not apply to an activity or an undertaking which cannot be treated as an industry, that is, where an activity or an undertaking does not answer any or all of the triple tests, namely, the first one, extensions of a systematic activity. The second one will be extensions of cooperation between the employers and the employees. And the third one will be the production or distribution of goods and services calculated to satisfy the human wants and wishes which are of material nature, that is to say, which are not of spiritual nature. The Supreme Court has laid down workmen of Imaguchi Tea Estate, Assam, Kamachi, Saga. Imaguchi Tea Estate. The Supreme Court has laid down workmen of Imaguchi Tea Estate, Assam, Karmanchari Sangha, Imaguchi Tea Estate, that the definition of industrial dispute contained in this Act can be divided into three parts, namely, the number one will be factum of dispute, and the number two will be parties to dispute, and parties to dispute employers and employers, or B will be employers and workmen, or C will be workman and workman, and the third one, subject matter of dispute, which is to say that the dispute should be corrected with A, B, C. The A will be the employment or non-employment, or B will be the terms of employment, or the C will be the conditions of labor. What is dispute or difference? Now I will explain. The dispute or difference must appear clearly, definitely, and the real substance of it must emerge so as to become apparent. In other words, some grumble or a browse or a state of unexpressed mental education within a person does not constitute a dispute or a difference. Similarly, a personal quarrel, even when becomes apparent or expressed does not constitute a dispute or a difference. Unclear, Thornton, and N.K. Sen and others, Labor Appellate Tribunal of India and others, in order to bring a dispute or a difference within the purview of an industrial nature, there should be some element of its resistancy. The dispute or the difference must be such that it is likely to endanger the industrial peace in the activity if not resolved early. Conway word 3. The difference parties to a dispute or a difference are also specified in the Act. Going by it, certain types of disputes or difference may never fall within the scope of the definition. For example, a dispute occurring between the government and an industrial establishment or between workman and non-workman does not constitute industrial dispute. And the Madras Gymkhana Club Employees Union and also Gymkhana Club, the objective of the Act is to be predominantly beneficial to labor, non-thistling. Just as a dispute raised by a workman by making certain demands on the employer may become an industrial dispute. When such demand is rejected by the employer, so also would a dispute raised by the employer by making certain demands on the workman become an industrial dispute. When such demand is not made by the workman under Burman Shell Oil Storage and Distributing Company of India Limited and Government of Tamil Nadu and others, an industrial dispute cannot be said to exist until and unless a demand is made by a workman on the employer and such demand has been rejected by the employer. If the workman does not make a demand on the employer, no industrial dispute will come into existence. Rejection of the claim of the workman by the employer in the conciliation proceedings before a conciliation officer will give rise to an industrial dispute before a conciliation officer will give rise to an industrial dispute. Fedders Railroad Corporation Private Limited, Lieutenant Governor Delhi and others. This decision is open to question in the light of the judgment of the Supreme Court in Bombay Union of Journalists, Hindu Bombay and others, that where a demand has been made by the workman and rejected by the employer before the date of reference, whether directly or through the conciliation officer, it would constitute an industrial dispute. Bombay Union of Journalists and others, the Hindu Bombay and others, the operating words in this judgment being before the date of reference, operating words in the judgment being before the date of reference, it is safe to reconcile the Delhi High Court judgment in Fedders Railroad Corporation's case supra by inferring that where the demand made by the workman is rejected by the employer on or after the date of reference either directly or through the conciliation officer, such rejection would not bring about an industrial dispute. The Act does not lay down the method of making the demand to be followed by the workman or the method of refusal to be followed by the employer. How the demand should be raised cannot be a legal notion of fixity, rigidity. There should of course be a communication of the grievances of the workman and the demand for its redressal to the management. The means and the mechanism of communication to be adopted are not matters of such significance. What is significant, however, is the question whether such demand of the workman had reached the management. Mr. Ramakrishna Mills, Coimbatore Limited, Ganapati Post, Coimbatore, Government of Tamil Nadu and others. That means that an oral demand or expression of grievances and its oral rejection will effectively bring industrial dispute into extenses equally as a written demand or writing rejection would, where a dispute referred by the workman was contested by the management on the ground that such dispute had not been included by the workman in their character of demands, and that therefore an industrial dispute did not come into existence. Such contest was not admitted as a valid contest. The decision would then be in favor of the workman if, of course, there had existed a communication of sorts of the dispute to the management by the workman. The chairman, Bank of Cochin, and others, all Kerala Bank Employees Federation and others. Industrial dispute should relate to an illegal wrong. A dispute does not become a industrial dispute if its nature is merely metaphysical, theoretical, philosophical, or ideological. That is to say, the genius of a conflict must be connected with the terms of employment or concerned with the interpretation of inferences in the course of employment. Thus, a workman may have ideological differences with the employers. A workman may feel sympathetic for an employee in his own industry or in another industry. A workman may feel seriously agitated about the conditions of labor outside our own country, but it is absurd to suggest that any of those factors but it is absurd to suggest that any of those factors would entitle a workman to raise an industrial dispute within the meaning of Section 2 of the Act. A dispute whether a particular union alone is competent to represent them is obviously not an industrial dispute. If the dispute is identified and indefinite or vague, it might disqualify itself as an industrial dispute by reason of its own extravagance. What becomes then necessary is to clearly preserve a dispute to become as a trade dispute divested of any political overtone. The Act does not give protection to the labor when a dispute is raised predominantly for political purposes. In reality, however, no workman would admit that his dispute is of a political nature even when he raises one with a political motive. In such complex situations where a dispute sits equally between industrial and political areas, the decisive legal factor should become delectable. Such elucidation of motive offers a profound difficulty, especially when the dispute is at the heart of an economic or social crisis. Disputes considered industrial disputes according to the Act. The second schedule and the third schedule of the Act enumerate disputes which are considered as industrial disputes for the purposes of the Act. A dispute which is probable as industrial dispute but not covered by either of those schedules shall be considered to have been covered by the residuary item number 6 of the schedule and the second schedule. General Secretary, National and Grainless Bank Employees Union, Madras, I. Khannan and others. And also collective bargaining and individual dispute. The intention of the legislature behind this act is protection of workmen as a class in their conflicts with employers. In Section 2, under Section K of the Act provides large enough a scope to cover a dispute between the employer and a single employee. Nonetheless, it would appear from the general pattern of the Act that the law contained in it contemplates that disputes for adjudication should involve legal wrongs perceived by workmen as a class. Budget and Budge Municipality, Sri P.R. Mukherjee and others, where a dispute is raised by a single employee expressing a specific grievance affecting him or her alone. Such disputes may develop into an industrial dispute when a class of workmen to which the disputant belongs under a banner of a union or even otherwise. A concerted demand made by a class of workmen for redressal of an individual dispute will become an industrial dispute. In other words, an individual dispute not taken up by a class of workmen acting in correct would not be eligible for the applicability of the Act. Bombay Union of Journalists and others to the Hindu Bombay and others, however, in Western India Match Company Limited, Western India Match Company Workers Union. The Supreme Court held that the community of interest does not depend on whether the concerned workman was a member of the union or not at the date when the cause occurred for. Even when his being a member, the dispute may be such that other workmen, by having a common interest therein, would be justified in taking up the dispute, exposing it as their own. Size of the class exposing individual dispute. The Act is silent on the question as to the member of workmen necessary for the constituting the class for exposal of an individual dispute, even where a class of workmen exists in an establishment in the form of a union or any other arrangement. The Act does not require that a dispute or a difference should be raised by all of the workmen in the class or even by a majority of them before making an individual dispute into an industrial dispute. The courts will not look into the questions of fact regarding whether a union exposing an individual dispute is a minority union or even an unrecognized union. What is necessary for admitting an individual dispute also under the Act is that there should exist a potential cause of disharmony which is likely to endanger industrial peace, and where a given number of workmen raise their voices in concern about it. Indian Oxygen Limited, the workmen were one in some a dispute and become an industrial dispute only if it is taken up collectively, and a collective dispute does not mean that all the workmen or a majority of them should expose it. Trade unions sponsoring an individual dispute. First of all, it is not necessary for the existence of a union of workmen in an establishment. Where there is no union in an establishment, it is sufficient if a group of employees sponsor an individual dispute to make it an industrial dispute. Workmen of Dharampal, Premchand, Saugandhi, Dharampal, Premchand, Saugandhi for two. The sponsor union needs to not be a registered union or a recognized trade union. Even where a trade union ceases to be a registered trade union in the course of the proceedings, such fact would not hit the maintainability of the order of reference, management, Government India Limited, State of Orissa, and others, where a trade union which has sponsored an individual dispute ceases to exist during adjudication proceedings and a new union comes in as a successor, the dispute does not cease to be an industrial dispute. On the question whether the individual disputant should have been a member of the union exposing his cause and whether such membership should be on the question whether the individual disputant should have been a member of the union exposing his cause and whether such membership should be anterior to the date of adjudication and not subsequent to it. High courts have held differing opinions. Bharati Ratnam and Company, Guntur, Industrial Tribunal and others, Shamsuddin, State of Kerala and others, Khadi Gramodiak, others, Khadi Gramodiak and Bhavan Workers Union, E. Krishnamurthy and others, Bullers, others, workmen of Jamodaba, Collier of Tata Iron and Steel Company Limited, Jamodaba, Collier of Tata Iron and Steel Company Limited, Jamodaba and others. In these cases where a detached workman had ceased to be a member of the union after his being detached, these employers' contention on the admissibility of the dispute as an industrial dispute as rejected, as otherwise no union would, however, expose the cause of a detached workman. Again, whether the workman became a member of the union after his dismissal and was not a member at the time of the exposure of his cause by the union, the dispute was admitted as an industrial dispute. When the sponsoring authority subsequently withdraws its support to the dispute in the Bombay Union of Journalists and others, the Hindu Bombay and others, answering the question whether an individual dispute continues to be an industrial dispute when workmen withdraw support to a cause previously exposed by them. The Supreme Court laid down that the crucial test should be the presence of the espousal and support of the dispute by the union of workmen, or by an appreciable number of them as on the date of reference. Arising out of this view, it is maintainable that subsequent withdrawal of support of workmen will not diminish the characteristics of the dispute being an industrial dispute, as a reciprocal reasoning whether a dispute which was an individual dispute at the time of reference will not transform into an industrial dispute only because of the subsequent support received from a class of workmen or a union. Subsequent withdrawal of dispute by the individual workman. Upon a class of workmen or a union sponsoring the individual dispute, there is an emergency of an industrial dispute. A subsequent request made by the individual disputant for withdrawal of this dispute will not make a dispute by any the less an industrial dispute. Workmen of Dalmia Cement Bharat Limited, State of Madras. Holding the same view, the Patna High Court also stated that the principle underlying is that when an industrial dispute is raised by a union or a group of workmen on behalf of an individual workman, the dispute ceases to be one between the management and the individual workman concerned. Eastern Management and Mineral Limited, Cybersagar Industrial Tribunal Central, than and others. Once a union takes up the dispute, a subsequent request made by the individual disputant for withdrawal of his dispute will not make the dispute any the less an industrial dispute. Workmen of Dalmia Cement Bharat Limited, State of Madras. Holding the same view, the Patna High Court also stated that the principle underlying is that when an industrial dispute is raised by a union for a group of workmen on behalf of an individual workman, the dispute ceases to be one between the management and the individual workman concerned. Eastern Manganese and Mineral Limited, Sibsagar Industrial Tribunal Central, Dhanbad and others. Once a union takes up the dispute, the parties to the dispute will be the employer and the union to the exclusion of the individual workman. Dr. Chandrakala Jha, Some Valley Portland Cement Limited, Company Limited, Jablan and others. Thank you friends for watching the video, and I'll come back again the contract of employment and the employment or non-employment. Thank you for watching friends. Bye bye.